And now we're recording. All right. Well, good morning, everyone. Thank you all for coming and welcome to this month's edition of the Joint Speaker Series, co-sponsored by the American Society of International Law's Organized Interest Groups on International Law and Social Science, and the European Societies of International Law's Interest Group on Social Sciences and International Law. My name is Mark Pollack. I'm the co-chair of the ASIL ILAS section, and it's my pleasure to welcome you all to this third online meeting of our Spring 24 series. Today, we're going to be hearing from our speaker, Taylor St. John, who's presenting a fabulous new paper on bargaining in the shadow of awards, which she has written with a stellar cast of co-authors, and I don't have to read them to you because you see them right there on the slide. And we have two stellar discussants today, namely Rachel Brewster and David Biggie. I do not want to spend a lot of time on preliminaries because we only have an hour, and I want to let our speaker and our discussants and our audience members weigh in. So let me just say a couple of sentences about each of our presenters. Taylor St. John is a researcher at the University of Oslo on leave from the University of St. Andrews. She is the author of the 2018 Oxford University Press book, The Rise of Investor-State Arbitration, which is a terrific combination of historical institutionalist theorizing and archival empirical research into the origins of ISDS, and a well-deserved winner of the IPE Best Book Award from the International Studies Association. She has also been doing remarkable participant observation scholarship with Anthea Roberts on the working of the UNCITRAL Working Group 3. And in addition to all of that, she is leading the University of Oslo's Compliance Politics of International Investment Disputes project, which is what we're, I think, going to hear about today. So Taylor has said she's going to start us off with about 20 minutes summarizing the paper, which is going to be hard to do because it's a rich paper. And then we'll proceed to our two discussants. First, I think we will hear from David Biggie, who is attorney advisor at the U.S. Department of State. He has, I can't even begin to talk about all the things he has done in that capacity from 2016 to 2019. He was the U.S. agent to the Iran U.S. Claims Tribunal. He has served as deputy agent in 2 cases at the International Court of Justice. And he's the primary point of contact for the U.S. for the International Criminal Court, the Permanent Court of Arbitration, and the UN Residual Mechanism for Criminal Tribunals. And he served for 6 years on the team that represents the US in investor-state dispute settlement, which is no doubt why when I asked Taylor about her dream team of discussants, she mentioned Dave, and then she mentioned Rachel. So Rachel Brewster is the Jeffrey and Betty Sue Hughes Distinguished Professor of Law at Duke University. She's co-director of the Center for International and Comparative Law. And like Taylor, she is a truly interdisciplinary scholar, having earned her JD at UVA and her PhD in political science at UNC Chapel Hill. She has made seminal contributions to IR theory, to the theory of reputation in international law, to WTO law, WTO dispute settlement and compliance, and more recently, global anti-corruption. I could go on all day, but I'm not going to because I want to turn it over right away to Taylor. Taylor, please take it away and welcome.
Thank you so much, Mark. That was such a kind introduction. And thank you to everyone involved with putting on this seminar series. I've attended every one so far, and it's really been terrific and so much fun. And I would, of course, also like to thank Rachel and Dave. Rachel, when we started this research project in Oslo, your paper, we started a little reading group, and I think your paper was, I think, the very first one that we read on compliance. And of course, Dave, your experience, insights from experience are really invaluable. I think particularly on a topic like this, which, as many of you know, can be really hard to observe from the outside. So as Mark alluded to, this is part of a much larger project that's ongoing at Oslo. And this is one paper from it, and it's a theory building paper. In the words of political science, it's a sort of exploratory project that we started after we collected data about many different post-award processes And we realized the existing categories and the ways of thinking just didn't seem to fit with what we were finding in the world. So fundamentally, this paper is about a search for concepts that fit. It's a search for ways of thinking that enable us to see and appreciate the varied and interesting dynamics that often occur after an interstate arbitration award, or sorry, investor state, important distinction, arbitration award is handed down. And so what I want to do today is start with a few details about the larger empirical project, and some members of the larger team are here today, so hopefully I'll acknowledge them as well, and then move to the concepts and the ways of thinking about compliance or post-award processes that we're putting forward in this paper. So in 2021, what was then Pluricourts and Malcolm Langford in particular received a large grant to research the compliance politics of international investment disputes. And so Malcolm and others here assembled a team of 26 researchers with varied legal and linguistic expertise to research what happens after ISDS awards are handed down. And as you see in this figure from the recently published database paper with Nicholas Strain as the lead author, what we're really interested in is that 221 cases where compensation was awarded. So a state is ordered to pay a claimant compensation. And just a few quick asides on this figure. First, even though we're really going to talk today about that 221 case box, many of the other boxes in this figure are also extremely interesting, right? So like the pre-award settlement box, I think is very interesting. There are also some caveats that I want to make today and that I wish were standard in investor state work generally. So first is these numbers are only the known cases. And in this project, we, like almost all scholars, are looking only at what happens after treaty-based cases. And I'd love to discuss these caveats and why I think they really matter during the question and answer period today. But for now, I want to get on to our project. So our goal in COPEED, or one of our goals, was to see what public information existed about what was happening after awards in which a state was ordered to pay compensation. And when we started the project, we were working with sort of more traditional definitions of compliance, right? Compliance as full execution of the action called for in the award, basically. And most ISDS awards order a state to pay a specific amount of compensation to a claimant, as you see in this Tethian award on the slide. In general, there are no other remedies, right? The state cannot be ordered to change policy. It can only be ordered to pay. So you may be thinking, well, code and compliance should be pretty simple, right? Like the state pays or it doesn't pay, or they pay some and then we have partial compliance, or they pay but slowly and then we have delayed compliance. And sometimes it is that simple, right? So sometimes there is voluntary compliance where a state basically sends an investor cash and then posts the receipts on a government website. And as you see on the left of this slide, Mexico does this. Almost no other state does, but Mexico does. Sometimes there's also involuntary compliance. So if state assets are seized or ordered to be seized in a third country, sold, and the proceeds are sent to an investor. So in the middle of this slide, you see Franz Sedlmayr, who is a German man who brought around 80 different subsequent proceedings across a range of national jurisdictions after winning a small award against Russia. Eventually, Russian-owned apartment buildings were sold to satisfy the Sedlmayr award, but it took a long time. And there are also cases of principled non-compliance, where a state says, well, we're not going to pay, and here's why. So on the right, you see a statement from the Ukrainian government trying to prevent courts anywhere in the world from seizing Ukrainian assets to pay Russian investors, right? So all of these sorts of instances can be well understood using the concept of compliance, right? Sometimes it really does work. We don't need to go any farther. But what if And these are all real case examples. The disputing parties sign a post-award settlement that a different amount will be considered as full compensation. Or what if a state pays with a new license or a regulatory change? What if a new investor pays the award amount to a claimant and then receives a future tax holiday? What if the disputing parties reconstitute the claimant's ownership structure and in so doing agree that they resolve the dispute? Are these actions compliance? And I think some of you may be thinking, well, these examples are anomalies. And that's fair. But I think as Bob Keohane has taught for a long time, anomalies can be really helpful prompts for theory building. And I would say what at first seem like anomalies are actually fairly common ways of resolving disputes. So in our COPID work, we found public evidence of payment, any amount at any time, in 101 cases. This is Strain et al. So that's around 46% of our population. But we found public evidence that a case was resolved, which we're defining as considered to have gone away by the disputing parties, a kind of rough and ready definition, in 61% of our population. So if we're looking narrowly at payment, or what we could think of as compliance with what the award ordered, we're missing a pretty big fraction of our population. And therefore, even though the kind of fixed standard approach to compliance is straightforward, and I think it's really useful in other contexts, in this context, its simplicity means that it may exclude some of the dynamics that are happening after ISDS awards. So therefore, we suggest a new concept, resolution, which focuses more on satisfaction. So again, as I mentioned before, it's a kind of rough and ready. Do the disputing parties believe that their dispute has gone away? If so, then it's resolved. And surely, right, I'll be the first to say measuring resolution is not as parsimonious as measuring compliance. But its advantage is that I think it may more accurately reflect how states and investors see post-award options in practice. And I think another benefit of resolution is that it leaves open what the claimant hopes to achieve. So if a respondent state is lucky enough to have the actual investor remain as the claimant, rather than, say, a litigation funder taking over, then that investor may actually prefer a policy change or a license being granted rather than compliance with what the award orders. It's possible, right? And of course, resolution also leaves open how a dispute is resolved. So perhaps through negotiations, perhaps through other legal proceedings. Something that I'll come on to in a few slides is that it's not that uncommon for a claimant to be a claimant in a case in national courts, maybe in a commercial arbitration, and also maybe in a treaty-based arbitration, all more or less at once. So a state may pay one award and then agree with the investor that that makes all three of those, for instance, legal cases go away. So that could also be resolution, where that would be a little bit harder to think about if we're thinking with kind of compliance as our core concept. So what we wanted was a framework that was open enough for us to see the interaction of legal and non-legal processes, and open enough to encompass a wide range of different actors and different dynamics. And what we ended up with is a core of our framework being the assertion that awards are focal points handed down into a context of ongoing bargaining. So the first step of the framework is to see awards as focal points. And this, of course, builds on Schelling's concept of focal points, right? Or outcomes that stand out as an obvious or a correct way to move forward. And focal points serve a coordinating function. Of course, treaties can be understood as focal points. Lauge Paulsen and ISQ a few years ago argued that European states intended investment treaties to serve as salient focal points for the informal resolution of investment disputes. Judgments can also and have also been understood as focal points. So Tom Ginsburg and Richard McAdams argue that ICJ judgments sometimes construct focal points. And they observe, and I think David will touch on this, that the ICJ works best when it solves these coordination type problems. The second step of our framework then places these focal points into a context of ongoing bargaining. And so here we're building on Christer Jonsson and Jonas Talberg, who introduced the term compliance bargaining, I think, although Mark, you can correct me on that. And then later work from Talberg and James McCall Smith, who argue that states bargained for settlement at multiple stages of international dispute resolution. They argue for settlement before recourse to proceedings, during, and in the aftermath of legal rulings as well. So in my view, with this framework, what we're hoping to do is appreciate more of the sophistication of actors' post-award strategies. Because I think after awards, disputing parties have possible moves in court, and they also have possible moves out of court. And what I think is really fascinating, speaking just for me, not for my co-authors, is how these actors combine legal and non-legal tools into one more or less cohesive strategies. Because actors may not choose legal paths as a sort of pure alternative to negotiations. They may choose legal tools as part of their overall strategy, including negotiations. So, for instance, some firms have brought ISDS cases as a tactic to strengthen their bargaining position in ongoing negotiations with a state. They're not necessarily seeking to resolve the dispute through the legal process. What they're looking for is new focal points from arbitrators to strengthen their hand in the bargaining. Or, of course, states have options too. So they can file annulment or revision proceedings to kind of block enforcement temporarily and give the negotiations some more time, right? So I think it's important when we think about actors in the post-award space to think about them moving across different venues or meeting each other possibly in different venues. Yet, and this is the key to our framework, once an award is handed down, that award becomes a focal point that influences how parties bargain. So we think that the range of possible outcomes is then narrower than it was pre-award, right? And I want to, for the rest of my time, discuss how this worked in two cases that I see as kind of least likely cases, least likely for the award to be a focal point, because in both cases, the state was either unable or unwilling to pay the entire amount, and the tribunal had produced a damages figure that really genuinely surprised both the disputing parties and observers. So these are not cases that we would expect this to work as well. And the first of these two cases is in 1997, a tribunal ordered what was then Zaire to pay $9 million to AMT, plus 7.5% interest per year, after finding that two instances of rioting in the Congo led to property damage, and that property damage then was a violation of the US-Zaire investment treaty. So the claimant made efforts to enforce the award. Zaire, which during this time becomes the DRC, then sought revision of the award, and that revision is likely an attempt to try to stall enforcement against state assets in the US. While the revision proceedings are pending, the now Congolese government makes two agreements that resolve the dispute. And in the first agreement, the DRC agrees to pay compensation. And in the second agreement, which you see here, the Congolese Ministries of Finance and Petroleum enter into an agreement with 3 new oil corporations. And these new investors commit to paying the old investors directly, and then in return, they receive tax credit. And so it's difficult to understand these kind of dynamics with a fixed standard approach, right? Is this even compliance? I remember Isabella, when she's part of our team, and when she found this, kind of asking these sorts of questions, right? Is this compliance? We actually don't know if these agreements were honored, because all of this bargaining took place during the Second Congo War. But our framework, in contrast, I think does help us to at least make sense of these dynamics. Because what we know is that the award in this case acted as a focal point. So despite the tribunal-appointed damages expert tallying 4.5 million for damages, despite a tribunal member dissenting strongly that damages should not exceed 4 million, despite the tribunal providing not a single word of explanation about how it reached its damages figure, it seems from all available evidence like this $9 million figure became the outcome that the parties coordinated around. And although available evidence is limited, it looks also like the claimant and the respondent both used several different legal and non-legal bargaining tools to resolve the dispute. And what we know is that there was resolution because AMT and its leadership continued to invest in Zaire DRC, and they continue to work closely with the government even today. And then the second example will be possibly more familiar to some of you. In 2019, a tribunal ordered Pakistan to pay $5.9 billion to the claimants in Tethian copper. And what you see on this slide is a sort of simplified timeline. So Tethian applied for a mining license in 2011. Province of Baluchistan denied the application. Shortly thereafter, Tethian brought 3 different legal proceedings in Pakistani courts, at the ICC in Paris, and then an ISDS claim at ICSID. And in 2019, the ICSID tribunal handed down its award, and the amount took observers and Pakistan by surprise. I remember, I'm old enough to remember that just before this award came out, estimates among experts were usually below or around $1 billion. But since the tribunal permitted discounted cash flow, they ordered Pakistan to pay $5.9 billion. And that amount, for context, is larger than Pakistan's education or health budget. It's also larger than an IMF bailout package that year. It's such a large amount that payment was not seen as a realistic option by Pakistani officials, right? They can't go to the Ministry of Finance and ask for $6 billion. But at the same time, they were afraid of what one official called the Argentina example, of having trade preferences suspended by the US, of having multilateral lending possibly stopped as a consequence of not paying. So therefore, after the award, Pakistan began annulment proceedings. They made an application for revision of the award. And again, that pauses enforcement proceedings in third states. And meanwhile, Pakistan assembled a strong negotiating team. They got representatives from Baluchistan, representatives from different ministries, as well as international advisors. And then it's through 3 years of negotiations that a settlement agreement is reached that restructured the project ownership and resolved the dispute, contingent on the project receiving different licenses and Supreme Court approval. So in this case, again, compliance is not particularly helpful because officially Pakistan doesn't necessarily pay what the award orders. But if we see the award as a focal point that reoriented the bargaining, I think we can get more traction into the dynamics that ultimately resolve this dispute. And I think because I want us to have a discussion and hear from Rachel and David, I'm going to conclude by saying that I think dynamics at work in this settlement by Pakistan also point to a few kind of tentative conclusions, which here I've framed as sort of directions for future research opened up, I think, by this framework. And on the left are sort of concrete steps forward in ISDS. And here I want us to kind of take heed of what Daniel Peat has argued in what I think is a fantastic recent paper, where he says we need to look at the process when we're thinking about compliance or post-award dynamics. Because while, of course, decision-making from state officials is still central, we also need to think about how actors relate to each other and who the other actors that are involved in these processes. And so here I've put 3 possible suggestions. And first is the identity of the claimant, which may be really important. So of course, Pakistan is lucky in this case that the claimants remained mining companies, and the mining companies want to mine, right? So they don't sell the award to litigation funders. Because litigation funders may be less likely to settle, as Florence DeFay and Zoe Williams have observed. Of course, home state involvement can also be critical. So we know that in another case, the Kyrgyz Republic doesn't pay. The Swedish government goes and leans on them quite a bit, and suddenly the Kyrgyz Republic pays, right? We don't know so much about how this worked here, but it may have been a factor. We also know that, of course, international institutions and the way that powerful states may be working through those institutions can also be important, right? Pakistani officials are gravely concerned about losing trade preferences from the US. They're concerned about World Bank funds being cut. They know this has happened to other states. It's shaping how they're making decisions. And of course, on the right side of this slide, our paper is, we're keeping it limited to ISDS. But I think it's also interesting, at least, to think what of this could apply to contexts beyond ISDS. And so here I've framed these as questions. What are the implications of moving away from compliance as a concept? I think I'm fairly comfortable with these in ISDS, but I'm really unsure about how they generalize. I'm unsure if we should see ISDS as exceptional when it comes to this sort of bargaining, or if the framework that we outline here could be useful in other contexts as well. So that was a brief introduction, but I'll leave it there. And I'm looking forward to hearing from everyone else. Thanks.
All right, I guess it's my turn. Oh, Mark, you're on mute.
So thank you, Taylor. That was a fabulous presentation, and you did justice to the paper and added some stuff that those of us who read it hadn't seen. So Dave, you have a lot to talk about. Please go ahead.
I sure do, and I'm going to try very hard to stay within my allotted 5 to 7 minutes, but I make no promises. And I apologize if everyone hears some noise. As soon as Taylor started to speak, some sort of construction project happened next door, which is, of course, inevitable. So if there's background noise, I apologize. Well, first, thank you to Mark and to the interest groups for inviting me to speak. This is very exciting. I was especially excited to read the paper and to hear Taylor's talk. I think this is actually, she and her co-authors have done a really important project here, focusing on, as noted, post-award discussions as opposed to pre-award negotiations. I should mention, by the way, in addition to the parts of my bio Mark read, I'm currently the Chief of Investment Arbitration for the United States. So I come at this from a lot of different angles. But I will say in that context that most of our discussions, at least that I've been a part of at a multilateral level, have been on pre-litigation negotiation, on settlement before the case really begins, before the states and the claimants have invested significant money in the process. But like Taylor, I do see a lot of value in focusing on the discussions that go on through the case and then especially after the case. I also think the reframing, which is I think the most important contribution of the paper, from compliance to resolution, is really grounded in the reality of how many of these cases end, as Taylor and her co-authors noted. I teach at Georgetown a few different classes, but one of them is on interstate disputes. And I always note the wide variety of statistics on compliance with ICJ decisions. But I think the distinction between compliance and resolution really resolves a lot of those distinctions, where some of the papers are focused on compliance and their numbers tend to be lower, whereas other papers are focused, I think, on resolution, although they don't acknowledge that, and their statistics tend to be higher. I have a couple of thoughts that arose both from reading the paper and from Taylor's comments just now. Again, I offer these as a full-time practitioner and only part-time academic, so it's with a mea culpa or with some humility, but I'll offer them for what they're worth. First, I think the paper does well to focus on states and the degree to which states are different than other litigants, because of course any litigant can have these sorts of negotiating strategies and focal points that are provided by an award or a judgment. But states are a bit different in this context. Interestingly, after I noted that I was going to be speaking at this event on LinkedIn, a former colleague sent me his work that is apparently being published with some co-authors on the same topic, but in the commercial context. So I think there's interest in both, but it's important to keep them separate, because again, states are a bit different. The paper highlights, and I think Taylor just mentioned, strategies that states have that commercial parties wouldn't have post-award, like thinking about sovereign immunity from execution. But it's not only that, I think it's more broader and conceptual, and it impacts the state's ability to negotiate. So, for example, as Taylor mentioned, the payment of an award is going to be drawn from a state's budget. Larger awards are going to be impactful on that state in terms of its generation of taxes or parts of the budget that would have been used for other public purposes. So ultimately, it's a state's subjects, its citizens or its residents that are going to indirectly pay for the award. And this means that the actual payers of compensation likely had nothing to do with the actions that led to the award. They're not the tortfeasors. They're not the shareholders of the corporation. They may, in fact, disagree very strongly with the measure or the government that took the measure. And depending on the time between the measure and the payment of the award, they may have been children when the measure was taken, or they may have not even been born when the measure was taken. Excuse me. This is research that has been undertaken recently by Sean Fleming and others focusing on this particular issue. And where the award is small, this is a negligible factor, but where this is what the paper describes as mega awards, or as Martins Paperinskis calls the crippling compensation problem, it becomes I think, a very significant factor on whether and how states settle. I think moving it in either direction, right? It could prompt a state to settle. It could make a state settlement more difficult. Similarly, I do think we need to focus on state constituencies and how those constituencies are going to react to the resolution of the dispute, whether it's compliance with the award or in some other fashion. As Taylor noted, the identity of a winning claimant may factor into whether the claimant is willing to settle, but it may also factor into the perception of resolution. And again, may make it more or less difficult to resolve. Changes in governing party may impact whether a state is in a position to resolve a dispute. The Argentina example was raised. Argentina settled those cases only after a change in administration. I will note, by the way, that the trade preferences issue was brought up a few times in Taylor's presentation. I was in private practice when all of that was going down, and I actually represented one of Argentina's creditors, but that was not in an ISDS situation. And in fact, it was Argentina's largest creditor, but they did not have an ISDS award against Argentina. They just held bonds. So I think the trade preferences issue, I think, extends kind of far beyond just the ISDS situation. I also wanted to mention quickly that the article, I think, assumes that states are like other litigants in that their preferences are going to be shaped and formed by the litigation itself. And although it wasn't mentioned in the article, I think this draws somewhat on David Caron and his theories about the bounded strategic space that states enter when they choose to litigate disputes in any forum. I do wonder whether that theory holds post-award. So on the one hand, states and I think claimants have an expectation about what an award means and how they are supposed to respond to it. But I do think that states find themselves much more bounded within the context of the litigation while it is ongoing. And then afterward, particularly if there's a public award and constituencies that would respond to it, I think they may start to behave more like states would in other contexts, in kind of regular negotiations, where they have to be more responsive to those constituencies. So my second point, and I think I can be very quick about this, is the article addresses the focal point provided by awards as a matter of expressiveness. And I was kind of focused on that because, of course, the ILC in the draft articles on state responsibility made very clear that compensatory awards are not themselves expressive. Now, I personally disagree with that conclusion, but it's there regardless. And I think there are two ways to think about that as a result. The first way, I think, is, as Taylor mentioned in her presentation, is to think of the focal points not necessarily as expressive, but as narrowing the range of shared possibilities. When two parties begin a negotiation, particularly pre-litigation or certainly pre-award, there's a wide range of shared possibilities between the parties, and to be useful in negotiation, they need to be shared possibilities. And the award itself will obviously significantly narrow those possibilities. It's what my friend Jonathan White calls a narrowing exogenous moment. But it takes sort of this wide array of possible futures and narrows it down into just a few possible futures. And of course, it's only useful in this regard if it's drawing on the shared, understood possibilities of the parties. And I think the Tethyan case is an example of where the tribunal deviated from those shared possible futures. The other way I think I would think about the expressiveness problem is to think about the elements of the award that are in fact expressive, which would be the determination on liability less than compensation. And I think this is where that ICJ research is very interesting. And in that respect, I'd be curious, and it's a question for Taylor, whether the research is going to consider only compensatory awards or will consider partial awards just on liability, or even partial awards on jurisdiction. And I think that research could be useful in practice, because if there is value in negotiating post-partial award as opposed to post-final award, that may encourage parties to bifurcate or tribunals to bifurcate through the different phases of the litigation and permit the parties to negotiate in between. I'll pause there. I've taken up too much time. I knew it was going to be hard, but thank you again to Taylor, and thanks to everyone for arranging this event. It was very interesting.
Thank you, Dave. That was fabulous. And I will throw it over to Rachel, who will also be fabulous.
Well, thank you, Mark. And Taylor, like David, I really enjoyed this paper. I thought the discussion, particularly of the enforcement architecture, was very useful, because I think that it really helps guide readers who might not be quite so enmeshed in the investment area away from this idea that, oh, investment is much more like civil litigation domestically, and it's, you know, not really a ripe area of international economic law with a lot of bargaining. And I think that that section really then opens it up to this idea that we should think about kind of what is compliance, are resolutions compliance, and what kind of activities we should be expecting both from investors and then from states. As you can imagine, I'm very open to the idea that, you know, kind of bringing in ideas of resolution, kind of opening up what compliance means. I mean, whenever you're dealing with international law in general, but international economic law, there's always these questions of, you know, kind of what does the treaty demand? And here, for instance, I think, you know, for instance, the World Trade Organization, they have preferred outcomes, but other permissible outcomes. I'm not sure where that lands with bilateral investment treaties, actually, whether, you know, there's obviously thousands of treaties, so there doesn't have to be one view. But for instance, within ICSID, you know, kind of how mandatory versus preferred full compensation payment is. But I think these are always kind of interesting issues to bring up, and this idea kind of in political science of just kind of like, what is a sustainable equilibrium for a system, and kind of how do we get the outcomes that we see. So my comments are largely just kind of accepting your idea that resolution is a nice theoretical innovation in thinking about compliance, and then kind of moving on to the framework and saying, if we're going to be doing research under this framework, what should that research look like? And trying to open up some ideas of what that research is, which is a really exciting idea. And I think your paper really invites it, which is why it was such a joy to read. My first statement is, to the extent that this is the direction you're going, you might, you know, be really interested in the other major international economic law, which is trade law. I mean, I think trade law has been dealing with this idea of, even if it's not called a focal point, this idea that you have merits litigation. That litigation is then put to bed when you have some sort of award, and, you know, within WTO, you get a suspension of concessions rather than a compensation award. But, you see a lot of these same bargaining dynamics where, a lot of the issues of the merits just cease to be relevant, and it becomes much more about what is the state authorized to do? How much pain can they inflict on the respondent state? What are the different strategic things that they do? Like how many industries do you list? Which industries do you pick? How much can you switch those industries up? And kind of also out of that strict suspension of concessions, other litigation opportunities, or kind of out of litigation strategic opportunities as well. And so I think that, if you're interested in these type of dynamics, I think that there's a lot of research in international trade that you might be interested in. So the next question, when I was thinking about your framework and specifically some of the resolutions you see, I was wondering how much we want to disaggregate the state. Because I think that the question becomes, it isn't just the state who's supplying some of these resolutions, but who within the state is able to supply some of these resolutions. So I can imagine, at least for some states, not for all states, that to actually pay compensation, you might need to get the executive and the legislature on board. You might have to have multiple veto players within the domestic space wanting to have that outcome. And that might be very hard to do politically. But some of the things that you were mentioning, which is, for instance, not paying, but giving a new license, that seems like something the executive could do on their own, or giving a license to a new investor and having that investor pay the old investor. Those seems like mechanisms of trying to think about how can, a willing executive or maybe a willing agency there be acting as a state, even though the state of the whole isn't signed on. And here you might get some kind of, depending on the domestic structure of the state, kind of differences in the type of resolution behavior that they comply with. So, again, drawing on WTO research and US compliance with WTO rulings, the extent to which a US agency or the executive branch can just make the decision themselves to come into compliance, the US is far more likely to comply in those instances than when we need Congress to be on board as well. And so, so there's some empirics for the idea of, what type of behavior you see might be driven by who within the state is interested in doing this, and then kind of what that capacity is. The next thing that I was thinking about when I was reading your paper is how you're framing the bargaining going on. And it seemed like most of the time you were framing it as a very case by case or kind of one-off type bargaining. You get one award, one investor, one state. And I imagine that a lot of investment arbitrations are like that. But I was wondering how many times we should really be thinking about this as a repeated game rather than just a one-off game, right? So I can think of, with the advent of not only third-party funders at the front end, but then, as you mentioned, the sale of some investment awards on the back end, you could have, kind of on the complainant side, a bunch of repeat players. And you can also have a number of states who are frequently in investment disputes. And you can imagine that that would change the bargaining dynamics significantly, right? So the states and the complaining parties are willing to hold out for longer. They're willing to engage in more costly activity. They're willing to bear more costs because they're worried about the precedential effect of these things. So it doesn't seem like in the Zaire arbitration that you discussed that there was really a repeat game there, but you can imagine other times where when you're seeing people really holding out, that there might be more of these repeat player dynamics. And here, kind of interestingly, is something that I don't see coming up in investment very often, but once we kind of move into your framework, I wonder how much we should start thinking about law firms as relative players. So, I mean, for investment law, you get these law firms who either represent plaintiff side or complainant side and state side. And they are obviously engaged not only at the litigation phase where you get the award, but then afterwards, right? To the extent that you're having annulment proceedings, you're trying to seize state assets, you're trying to continue to bargain. Those law firms are going to be resources of information and past knowledge and advice and strategy. And sometimes I wonder how much of this is really driven by the investors versus the investor law firms. So in this framework, it might be actually nice to try and theorize law firms in it in some way. And so my last two comments are are much smaller. My one had to do with, I appreciated your discussion occasionally of corruption in investment arbitration, particularly in the P and ID case. And so I wondered how much an issue like corruption or other issues could go through from the merits to post-award, how much they might upset focal points. So I understand under the focal point theory, the idea is a lot of the merits are put to rest, we get this award, and then we're moving on from the award. But it seems like corruption, and maybe something like in the Ecuador Chevron case, just kind of the vitriol between the parties, some issues might resist the focal point. And I wonder if there can be some theorizing about kind of issues like corruption, or I don't know if vitriol would be its own category, but kind of different issues which could break up the focal point. And then I also really appreciated your comment at the beginning that you're talking about investor arbitration and treaty-based arbitration and not contract-based arbitration. But I was wondering, and we can do it offline, how much, I think that it's what you're doing is absolutely relevant to contract arbitration as well. And how much of the sample that at least your previous study looked at is really if there's systematic selection bias between contract and investor arbitration. So we can imagine that really sophisticated parties and really large parties like energy companies are going to always have investor protection as well, but they're going to write their own contracts with the state and they're going to move into a different box. And so once we're talking about treaty arbitration, we're kind of talking about people who are either not sophisticated or not big enough to get a contract arbitration. So they're in a broader pool, and whether or not, the contract arbitration and the treaty arbitration groups are similar, and kind of whether we'd see similar dynamics. But again, I constantly, all these questions were coming up, and I have more for you offline, but thank you so much. I appreciated it.
Thank you, Rachel. So Taylor, you can see you chose your discussants well. You have more questions than you could possibly answer. So I'm going to give my standard advice, which is be selective, pick the questions that make you look smart, take a few minutes, and then for everyone else in the audience, if you have questions, I see Lauga already put up his little yellow hand. If you have questions, put up your little yellow hand, and we will come to you after Taylor has a chance to give her initial feedback. Taylor.
First, thank you so much. These were such fantastic comments, and I just nodded along. I think given that there are only 10 minutes left, I have made so many notes. I think I will respond privately, except to say, just to pick up on the very last comment, how much is the sample affected by not having contracts in what we see? I think, so my own personal view is that we've often been studying investment treaty arbitration as though that's the main thing, and contracts is sort of a sideshow. And I feel like actually contracts is the larger, bigger kind of, there's more money going into this thing. And also when we only study treaty arbitration, I think there's also a regional bias that gets introduced. So a lot of, when we study treaty, maybe we're seeing more of the kind of North American cases, but maybe we're only seeing 10% of the African cases against African states that are investor-state disputes. So I think there are so many things that are kind of different about the treaty-based pool to the contract-based pool, and I think as a field we really don't have a good sense of that. But I think I may just open up for more questions, except to say thank you so much, and I may email both of you with more kind of specific thoughts based on these comments because they were really fantastic.
Okay, terrific. Thank you, Taylor. And so, yeah, we have about 10 minutes left. We maybe can go a minute or two over. But I see 3 little yellow hands, Lauga, then Ezgi, then Anna. Maybe we should just take them all at once and you can take notes, Taylor, and we'll give you the last word. So Lauga, please.
Thanks, Mark. Can you hear me? Yeah. Okay. And thanks, Taylor. This is a extremely important project. It's nice that finally someone is doing work on these sorts of issues on investment. It's wonderful, and I think a lot of additional work can be done by you and the team. And so I think perhaps in that light, my questions are maybe for your next paper, not for this one, and I take it it's already been published anyway. But I wonder if you could tell us a little bit more about what is the underlying causal mechanism for how these awards function as focal points, or at least think about how you might be able to test that going forward. So is it the quantum, right? So is it the number that is the focal point, or is it just the fact that the government lost in the merits? I think that's sort of as an entry point. Presumably, I think it's both. But on quantum, it strikes me there's sort of various ways in which it may or may not serve as a focal point, and it was a little bit unclear to me in your talk. So maybe that's something you want to test going forward, right? So you in your slides and in the paper sort of present a theory that's along the lines of Schelling and McAdams, that somehow it functions as a focal point by provision of information, right? So you have a number, and that's information, and then parties can coordinate around that number. But so how does that explain then something like Techen, right? So that you mentioned yourself, where presumably the Pakistani government thought that the quantum was much beyond sort of the reasonable bargaining range because of how DCF was used, right? Is it then that the award just provides information, or is it something else that makes it focal? So that's the first question. Is it just information, as in McAdams and Schelling? Or is it about legitimacy, right? So is that number or what's seen as inherently legitimate? So is it legitimacy and not information that makes the award focal for coordination? And if that's the case, I think we should expect then the different effects of the award as a focal point depending on the host state's perception of ISDS or the tribunal, right? And this goes to Rachel's comments as well about the relationship between the parties. I think there's a lot of variation about whether and to what extent an award is seen as inherently legitimate as opposed to providing information. But a third mechanism could be that it's not so much information, it's not so much legitimacy, it's just legally relevant in the context of enforcement and execution. But if that's the case, is that maybe a little bit separate from your argument about focal points? You don't have time to engage on that here, but I think that might be useful, at least for me going forward with this very, very important project. Thanks.
Okay, and I asked Taylor an inferior version of that mechanism question, Lauga. So yeah, I'll be interested to hear what she has to say. Ezgi, please.
Thank you. I'll be brief. This was an amazing paper, great presentation and great discussion. I really enjoyed it. And I think the paper is so rich, and it's really making us think about something that I haven't heard or read in the literature before, because we hear about this argument about the shadow of courts pre-litigation, and you're showing us that what happens after litigation. I really love that. So I'm just, as someone who doesn't know this field very much, I was wondering about the implications of this argument, right? Like, what does it mean? Like, does it mean that the awards were not to be complied with in the first place? Like, do the arbiters, now we have also someone working in the field, do they know that they have this effect? And how would this influence their decision making in the first place and the way they decide awards? Since this is a large project, maybe I'm hoping that you can actually work on this other dynamics later on as well. Thank you.
Thanks, Ezgi. Anna.
Yeah, hi, thank you. Thanks, Taylor. That's a great paper. So I actually follow up on Lauga, what Lauga was saying. Also interested in the causal mechanisms, what's really happening there. And I would also follow him that it makes sense to distinguish the decision on the merits and the implication for what's good, what's bad, what's legitimate, was there a violation or not, and just the quantum. But I was wondering whether, when we go back to the original definition of focal point, it's where expectations converge, right? But they may not, like in the Pakistani case. On the normative side, there were no expectation converging. I remember in the last UNCITRAL meeting, the Pakistani delegate was, and basically the whole global south, they were like, that was crazy. So the quantum delegitimized the whole award. And so then one part of the causal mechanisms is not working, right? But I was wondering whether there's an additional psychological effect, which is anchoring. And anchoring not only works with numbers, it also works with legal entitlements. And I wonder whether that is something you would like to take into account, because the focal point not only stays very rational choice based, I think there's more going on when you start to bargaining post-award. And there's also, as Rachel has said, especially when you think about what's going on within the state, that might matter. So I just wonder whether you had some thoughts about it.
Okay, Taylor, you get the last word. We have a few minutes. We don't have to end exactly at 11. Yeah, whatever thoughts you might have.
Thank you. So I think, yes, Mark and Lauge and Anne fleshing out the causal mechanisms or various causal mechanisms, right, which might be at play in different contexts, I think is key, is the sort of next step that that needs to happen in this paper. I think, if I'm totally honest, I'm not exactly sure how it's playing out. I think certainly in my head, there's a sort of two levels to it, right? Where the first level is, okay, a violation has been found, right? So it's just the merits. And I think this can often happen much earlier in higher capacity states. So some preliminary interviews with litigators in very high capacity governments that have a lot of investor state litigation, they're able to kind of see if a case is going against them, and then they may act, as David suggested, they may act in these earlier stages, pre-award, right? Kind of earlier on, and settle or kind of do different things there. So I think there's a kind of something about kind of legal strength of a case or the finding of a violation that's already shaping state strategies. But I think then the amount of a case is almost a separate kind of, it has a separate effect. And I think that one, I think anchoring is a good way forward. I think, as David brought up, kind of narrowing the range of possibilities could be another way to think of it. I think there is, certainly in some situations, probably not in all, the number itself does do some work. But I think this is an area where, with my co-authors and others in the project, I think we have to think a lot more and kind of go and interview people who are making decisions about this. I think also, Ezgi, the implications of this argument are really interesting. And now that pluricourts has ended after 10 years, not everything has to connect to legitimacy, which is a huge relief for some of us. But I think I would actually like to go and ask arbitrators, right? Repeat investor state arbitrators, to what extent does it matter going forward for you if your decisions are kind of maybe serving as focal points to which parties agree to pay kind of a 60% or whatever they do going forward, if it's not a kind of final judgment to be executed exactly. I think I'm actually not sure. Some of them may already be former litigators, still be litigators, be used to this kind of thing. Some of them may see what they're doing as it's important for us to kind of state that awards are to be enforced exactly. So I think those are preliminary thoughts, but I've made a whole bunch of notes from this session. I have learned a lot from the reflections, particularly from Dave and Rachel. So thank you all so much. And the work continues here in Oslo.
Yeah, Mark, can I do something very awkward, but I just realized I failed to do it in my thing. I was supposed to mention, since this is being recorded, that I'm speaking in my personal capacity. Just wanted it on the recording. Thanks.
Absolutely. Absolutely, Dave. All right. So I'm just going to say, Taylor, this is a really rich paper. Thank you to you and your co-authors and your team for sharing it with us. Thank you to our fabulous questions from the audience, and especially to Dave and Rachel. Just a quick reminder, this series continues. We're not going to top this one, but this series does continue with Eric Voten and Celia Hermanson on April 24th. So please come back on Zoom to join us then. And in the meantime, we'll say goodbye and thanks. All right.